Hi, my name's Grieger. Thanks for joining me for this quick look at the use of consumer law in litigating medical disputes. Quick background on myself. My background is as a commercial lawyer. I'm not currently practicing law. I'm back at the University of Adelaide at the Adelaide Law School, both as a sessional teacher, also as a Masters of Philosophy research candidate. I'm looking at issues kind of in the intersection of health law and commercial law. I've taken an interest in medical law for quite some time now, but I guess the main influence is probably my partner is a midwife and a nurse, and so a lot of those discussions with her really, I think, influenced this desire to learn more about the way that law and healthcare interact. So this presentation I'm going to go through today, it's a talk that I gave at the recent AABHL, Australasian Association of Bioethics and Health Law Conference in Hobart in November 2022. I was already thinking that I wanted to be able to make this information available to a general audience, as I have been told by a number of people that are interested to hear what it was that I presented about. I also found out that the audio recording from my presentation didn't work, so figured two birds, one stone, may as well re-record it and make it available through both formats. So what I looked at in this presentation was this idea of connecting the old and the new in litigating medical disputes, looking at the traditional approach of medical negligence and the emerging use of Australian consumer law. Now, I think a good way of starting this analysis and a handy way to set the scene is a look at a recent case that's been litigated in the Federal Court of Australia. It's quite a topical case and well known. So what's it about? Quick recap here. This is for anyone not familiar. Ethicon, Sàrl and Gill, it's a representative class action. It was brought against three subsidiaries of Johnson & Johnson, together referred to here as Ethicon. This really just has to be a quick recap. If you want to know more about it, you've got a couple of options. You can read the 1,500-page trial judgment if that interests you, or I'll link to a bunch of other work that I've done on the Ethicon matter as maybe a easier jumping off point. And feel free to reach out with any questions about this case or some of the other ones that I've mentioned. So this looked at the use of polypropylene mesh in treatment. It was a material initially developed for sutures. It was adapted into hernia mesh and then later adapted into pelvic mesh. That was for the treatment of pelvic organ prolapse and stress urinary incontinence. It was approved for sale as a new use of an existing device. This was due to the supposed substantial equivalence that it had with previous devices. This is despite new use on different anatomical sites. The female pelvis, very different to the abdomen, and the device was not suitable for new use with different tissue. The result of this was it caused a number of complications. They include chronic inflammatory reaction, extrusion or erosion of mesh into surrounding organs, damage to surrounding organs, nerves, ligaments, tissue, blood vessels, and chronic pain. During the cross-examination at trial, it was revealed that Ethicon, as the manufacturers, were aware that these complications existed from the time that the devices were first sold on the market. So that is, despite that knowledge, they did not disclose these risks to patients or surgeons, and that was for marketing reasons, as identified by the court. That is, it was not within their commercial interest to make these complications known to the either the surgeons or the patients. Quite simply, they wouldn't have sold their devices if the consumer, the patient, was aware of the potential complications it could cause. This is particularly concerning. It's concerning anyway because you've got instances of patient harm, but I guess particularly concerning when you consider how widely the devices were used. Approximately 90,000 of these, that is 90,000 devices were sold in Australia. So why the focus on Ethicon in this talk about connecting the old and new in litigating medical disputes? So next we've got a couple of legal concepts. The first is one that tends to be familiar to those in the medical profession. So broad generalization, but my assumption here is that most healthcare professionals tend to understand these core concepts of medical negligence. Simplified, that is that the providers of healthcare, and that's including manufacturers, owe patients a duty of care, are expected to meet the requisite standard of care, and when the breach causes harm, they are liable to compensate the patient. This is an attempt to restore the patient to the position that they otherwise would have been in but for the breach. And it's an example of the law and the professional standards aligning. Neither are conceptually difficult nor difficult to understand. The legal concepts that may be less familiar to healthcare practitioners. These can include terms such as misleading or deceptive conduct, safety defect, acceptable quality, fitness for purpose, unconscionable conduct, and unfair contract terms. What relevance do these terms have to disputes like Ethicon, Sàrl, and GIL, or broader field of medical law generally? They're Australian consumer law terms. They're now entering into the medical legal dialogue and becoming increasingly relevant to the provision of healthcare and particularly the litigation of those disputes. So whilst they may at this point be less familiar or unfamiliar to healthcare practitioners, the point of my presentation is the use of these is becoming more and more prevalent, and I think it's probably time to become more and more familiar with them as it's becoming an emerging use and a more frequent way of litigating disputes involving healthcare. So a real quick consumer law recap is primarily found now in the Australian Consumer Law, which is located in Schedule 2 of the Competition and Consumer Act 2010. Previously, consumer law was found in the Trade Practices Act and numerous other sources. It was consolidated into the ACL, the Australian Consumer Law, at the start of 2011, which explains why cases can often refer to one or the other, so ACL or TPA or perhaps both. It all depends on when the conduct occurred. So was it before or was it after commencement of the ACL, being 1 January 2011? In Ethicon, it mostly considered the TPA due to the timing of the conduct. Most of the conduct occurred before the ACL came into act. Here, though, in this presentation, I focus on the comparable ACL provisions. So the relevance that this has to Ethicon, well, the claims were brought pursuant to both common law negligence and the TPA and ACL provisions. The consumer law provisions that were applied in Ethicon were those relating to safety defects, acceptable quality, fitness for purpose, and misleading or deceptive conduct. There, the claimant succeeded in both the common law and the statutory claims. So they were successful both arguing negligence and that those provisions in consumer law had been breached. Now, to show this isn't an isolated use, this is just a quick gathering of some other examples of consumer law applied in the medico-legal disputes. Some are healthcare, some are health adjacent. Don't worry, I'm not going to go into them in any type of detail now, but it's really just to show that this isn't an isolated or a one-off use. It's something that's, if you look at the body of case law coming out, you can see this real emerging use of, I think at least, of consumer law to litigate medical disputes. So why would a plaintiff use consumer law? I guess if the statutory claim is the only cause of action, as in a claim in negligence for some reason isn't available, well, that makes sense. It's quite obvious why a plaintiff would then rely on consumer law if they didn't have an argument in negligence. But what about these examples like in Ethicon? So why would a plaintiff want to use consumer law when they already have a claim in negligence available? So in Ethicon, as I just said before, they brought claims in both. They succeeded in both. They elected, though, to receive damages pursuant to common law negligence, the reason being the amount was going to be greater. So why would a plaintiff decide to complicate things for themselves and initiate proceedings under both regimes? There's a couple of reasons. So the first is one way of protecting against one of those claims failing, hedging your bets. The second is that the use of consumer law brings with it an increased range of remedies. The ACL options are far broader than those under common law. In negligence, the primary remedy available is damages. In common law, equitable remedies, such as injunctions, are possible, but somewhat rare. In consumer law, though, the suite of possible remedies is much, much broader. So depending on the cause of action, those potential remedies, they could include damages, injunctions, pecuniary penalties, compensation orders, redress for non-party consumers, publicity orders, disqualification from managing the company, compliance programs, and other orders as the court sees fit. In Ethicon, the plaintiffs sought declaratory and injunctive relief pursuant to the consumer law remedies. Another quite substantial benefit of consumer law being applied to healthcare disputes is that the action can be brought by the independent statutory authority, so the AACC, the Australian Competition and Consumer Commission. This is a particular benefit, say, if those who are harmed by the actions of a defendant maybe don't have access to a class action. It's another option of the dispute being litigated. As you may have noticed in that previous slide, that was a bunch of recent cases involving consumer law being applied to medical disputes. The party, or at least one of the parties in a lot of those cases, was the ACCC. They were the party that were bringing the complaints on behalf of the public at large. The possible enforcement actions that the ACCC have available to them, that can be administrative resolutions, it can be infringement notices, can be enforceable undertakings, court cases, as were those cases above that we looked at, and there's also some other informal options available to them. So as far as the outcome, I guess the question really to end on here is this a novelty? Is this use of consumer law maybe a mere stopgap or something that's arisen that will go away quickly? I really don't think so. I think this is an emerging trend. I think that it's an appropriate use of a body of law. It's the response to the change in the medico-legal landscape resulting from this proliferation of technology and advances in medical treatment. It is one way, and it's the way that, I guess, the law has responded in addressing this clash of culture between business and healthcare, which is something that I focus on with my other research work. I'm not going to go into detail on that one here in this presentation, but I'm covering it in other areas. But this use of consumer law is one way to deal with this idea of a clash of culture presented by businesses placing commercial interests over patient well-being. It can be seen as, I guess, a medico-legal response to this issue by accommodating more than the traditional claims in negligence. The ACL use, it addresses patient harm, which can be physical, mental, financial harm, and that can be the result of medical or therapeutic treatment or devices, products, drugs. It can be quite broad, and it can really extend to those kind of beyond healthcare to healthcare adjacent, I guess, is one way to look at it. Now, there's a couple of issues that have been raised. I mean, I've thought about them as I've been researching. They've been raised by people that I've been discussing this with or presenting it to, and I just wanted to quickly touch on one of those here, and that's this idea of considering patients as consumers, particularly when I'm talking about this with healthcare practitioners. Red flags go up, which is fair enough. It's understandable for sure. This idea of the term patient and what that means, and the relationship of a patient with a doctor or a healthcare provider, that's a long-established relationship of trust and confidence, and special protections have developed as such. And it's understandable that, I think it's understandable that healthcare practitioners may be initially reluctant to think about patients as consumers. as I said, I'm considering this more broadly as part of my research, and I plan to talk about this and write on this a lot more in the near future, and we'll make that available wherever possible. But I thought I'd just quickly comment on it now, maybe in just two initial responses to this concern, and perhaps why I've come to think that this labeling or use of the term consumer for someone who is also a patient is perhaps less of a concern than definitely than I initially thought. It was something I initially took a bit of issue with, but I've come to think of it as less concerning now for a couple of reasons. The first is that by using consumer law, the legislators, the regulators, the courts, no one's removing the other options. Yep. So all of the previous manners that healthcare was regulated or litigated are still in place. You've still got medical negligence. You've still got the TGA, the APRA registration, potential criminal liability. That all still exists, all still with the recognition of the importance of the patient, the vulnerability of the patient, and the trust that they give to that they place in the medical practitioner. That still all exists. This just gives an additional arrow in the quiver in ways to deal with healthcare disputes, particularly litigating healthcare disputes. That's what we're looking at here. The use of consumer law, it's not so much about setting the requirements of practitioners or saying what's allowed and what isn't. It's definitely not saying patients are only to be considered consumers from this point on. Far from that. What this is doing is just giving another form of redress, another way of litigating when harm occurs, when someone is acting in a way that's contrary to the laws. And those laws, those consumer law provisions, they don't really vary from at least what I've seen and what I've looked into. They don't vary a great deal from how we would expect the parties to be engaging with each other in a medical context anyway, which moves on to this second reason why I've come to think of it being less of an issue than maybe it initially seems. Depending on the provision that is being argued, consideration is actually given to the relationship of the patient in that capacity. So they're deemed a consumer, they're referred to as a consumer, but they are a patient and they're considered as such, and their relationship with the respondent is taken into consideration, whether that be a manufacturer or the treatment provider, a doctor or otherwise, when determining the required or expected standard and whether it's being complied with. So when thinking about what a reasonable consumer in that scenario would have expected, that scenario being as a patient, so I guess the point being this special relationship, if you want to think about it that way, between patient and doctor, it's not forgotten about, it's not cast to the side. In fact, it's looked at when looking at and determining what a reasonable consumer in the position of this patient would have expected. And that differs depending on the individual provision that's being argued. So I guess it can almost be seen less as cramming patients into consumer law and more at applying patient and healthcare requirements into how the consumer law is being applied when you consider it in that respect. So look, I'll wrap it up there. I guess the other point that I finished on is whether it's time to maybe start recognising or conceptualising this use of consumer law for healthcare disputes as another limb of medical law, such as medical consumer law. I don't think it's a novelty. I don't think it's a trend or a stopgap that's going to disappear. I think if you look at the cases, you can see this emerging use, this emerging reliance, and it provides a lot of, I think, additional options. It's not replacing anything, and that's definitely not the point that I'm trying to argue, but it provides additional options when patients are harmed, or when their rights and their priorities are put to one side and commercial imperatives are favoured by the decision maker. All right, well, that's the end of my presentation. I hope you enjoyed it. I hope you got something out of it. I think it's a good thing to be aware of if you're in healthcare or health law, or you just have a general interest in this area. I think it's quite interesting to see how these medical disputes are being litigated and the different combinations of law that can be applied to reach an ultimate resolution for the plaintiff. Cool. Well, that's it for me. Thanks for joining. If you've got any questions, please do reach out. Always keen to chat about this. Until next time, thanks. See ya.